Hi there, my name is Diversified and today I will be talking about sponsorship of a member of the family class under the Canadian Immigration Act and specifically for spouses, common law partners and conjugal partners. In 2002, the Immigration and Refugee Protection Act was amended to eliminate the fiancé visa class, and what was introduced was the introduction of the common law partners as well as conjugal partners, which were added to sponsorship of permanent residence applications under the family class. What is very important to understand is the definition of the three, which is spouses. What does a spouse mean? Common law partner, what does a common law partner means? Who qualifies, who is eligible, as well as who is a conjugal partner, and how do you prove that a person is a conjugal partner? You can find these definitions either on the internet, on the Immigration and Citizenship website, or you can contact one of our DIVA Immigration Services counselors. At this stage, I think it's very important to mention that a person must be a Canadian citizen or a permanent resident of Canada to sponsor a person under the family class as a spouse, common law partner, or a conjugal partner. Also, I think it's very important to mention that Canadian citizens in Canada, living in Canada or living overseas, may sponsor a spouse, a common law partner or a conjugal partner for permanent residence, but a permanent resident living overseas cannot sponsor a spouse, common law partner or a conjugal partner. Hereafter, I will be talking about sponsors, and a sponsor would mean someone who's a Canadian national or a permanent resident of Canada, and applicants would be the foreign national who is being sponsored. In case of a sponsorship application for a spouse, common law partner or a conjugal partner, it's very important to go through the forms in detail. The forms for the sponsor include the sponsorship agreement, which the sponsor signs with the province that the sponsor is residing in, basically undertaking the financial burden of the applicant once they land in Canada for 3 years from the date of their landing. It also includes the sponsorship questionnaire and a few questions regarding the sponsor's status in Canada, their employment status, what is it that they do, as well as details of the relationship. On the part of the applicant, there are the permanent residence application forms, the background declaration, the additional family information form, which talks about the applicant's family overseas as well as in Canada, if at all, and also a spouse questionnaire, which basically talks about the relationship between the sponsor and the applicant. It is very important to detail the relationship between the applicant and the sponsor in a spouse sponsorship case. Also, what is very important to understand that in case of spouse cases, if it's an in-Canada spouse sponsorship, the sponsorship must be recognized by, the marriage must be recognized by the government of Canada. And if it's an overseas spouse sponsorship case, there should have been a legal marriage, and there should be a legal document to support the fact that there was a genuine marriage between the applicant as well as the sponsor. Also, it's very important for the sponsor as well as the applicant to show that there was a genuine relationship, and that also prove that this was a bona fide relationship and a bona fide marriage that finally led to the sponsorship application. For any more details with regard to overseas spouse sponsorship, regarding the processing fees or the processing time, you can get in touch with me, Diversified, or with one of our DIVA Immigration Services counselors. DIVA Immigration Services is a law firm, and an immigration law firm that deals specifically in immigration to Canada, Australia and UK, as well as it deals with temporary residence visa applications for Canada and Australia and the UK. Thank you.